I'm Jennifer Welty. I'm the Vice President of Sales here at Heritage Title Company, and I'm filling in for Jill while she's at home with her sweet little baby and Brady, who just turned, what, 4, 3?
He's 5. Brady's 5.
Where did time go?
And Quentin is now 7 weeks.
7 weeks. So 2 little boys probably going crazy at home. I don't know if these 2 need an introduction. I think you guys are like celebrities, especially your stand-up comedian shows that you guys take on the road. We're going to see you guys at the car convention this next week. But Scott Peterson and Damian Cox, again, I don't really know if you guys need an introduction. They all know you.
That's quite an introduction in itself. I prefer actually the introduction that Damian and I got this morning, our bios from this morning when we did a little road show in Vail. So yeah. Damian, something like Damian carries my briefcase or something like that.
Yeah, I think that's what it was. Is that and you just appease me with the ridiculous stuff that I come up with, forms and legislation or something along those lines. I really appreciate that one, Scott.
There's elements of truth in all of that.
Keith Alba just said that he can see your head getting bigger and bigger as the minute goes on. So we should probably get started, or else we might not get you in frame.
Thank you, Keith.
So Scott, tell us what's new with Car.
What's new with Car? Nothing's going on in the realtor world, right?
Yeah, I didn't hear of anything. Have you? You just
status quo, and all ships are sailing smoothly. At Car, obviously, they are. Things are relatively smooth, but there's a ton of stuff going on market-wise, and things that have implications on your business, on our business, and kind of how things are going to shape out over the next, 12 to 18 months. It's going to be a very, very interesting time for our industry, and it's been an interesting time, and things have really been, in some ways, moving pretty quickly. But I know, and I'm alluding obviously to some of the antitrust stuff and settlements and everything. And I thought maybe we'd start talking a little bit though first before we get into that, because that can carry us down a rabbit hole that might take us to the end. Talk a little bit about some of the stuff that I'm seeing on the hotline, and Damian and I talk a lot about the issues that we see. So the question, when it comes to hotline topics, one of the things that I've been really emphasizing this year in some of my education and speaking engagements has been the fact that year in, year out, I've been answering the hotline in some capacity, even as a contract attorney, from well before I started at Car, for probably 12 or 13 years now. And it doesn't matter what market it is, the 2 most common calls that we get, and I would say they comprise in some form or fashion about 20% of the total call volume, have to do with earnest money disputes or brewing earnest money disputes, or sellers, seller buyer, somebody's not signing a release, or there's some contention related to a deal that has blown up, and now they're starting to fight or thinking about fighting, or maybe attempting to mediate over the earnest money. And that's one portion of that total 20% call volume. The other portion that we get a lot of, or that I get a ton of calls on, is post-closing failure to disclose kind of questions. And a buyer broker often will call and say, my buyers closed, 3 weeks ago, they moved into the house, and we realized the seller didn't disclose this, whatever it is. And, kind of, who do we sue, or what's the next step? And the thing about both of those issues that I've been trying to focus on this year is realtors representing buyers or sellers doing a better job of understanding what their license is and what they're licensed to do in terms of performing brokerage functions, and the derivative importance there, what they're insured to do, so their E&O insurance when it comes to brokerage functions, and then what goes beyond that, and trying to help realtors understand that we need to get better to some degree as an industry about setting expectations and limits with our buyers and sellers with regard to the difference between the practice of law and the practice of real estate. In either of those 2 examples that I just gave, earnest money dispute, the foundational point was the deal blew up, right? There's no more real estate transaction. And in the post-closing failure to disclose situation, the deal closed. There's, again, no more real estate transaction. And what you're left with then is, because a real estate your licensure covers a brokerage transaction and performing a brokerage function, you end up in a situation where in either of those two scenarios, what exists really at that point is a legal dispute between a buyer and a seller. And almost invariably, buyers and sellers want you to be their free lawyer and to kind of carry the ball forward and to provide them with advice, or analyze claims, or analyze the potential for damages or the likelihood of success in a claim. And all of those things are legal functions, right? And all of those things, maybe most importantly, you're not insured to do. So if you don't do it well, and the buyer has some damages, or buyer or seller, your former client has some damages as a result of that, that's uninsured liability that you've created for yourself. And insurance companies are very good at collecting premiums. They're very good also at denying coverage or denying claims. And so being mindful of that as a sort of practice or best practice. And it's tough because you guys walk a very fine line when it comes to, you want to be everything to all of your clients, and you're helpful people by nature, by default. And so it's a difficult situation because, and you want repeat and referral business, obviously. And so not being able to kind of hold up your hand and say, that's not my problem, while it really isn't, doing that tactfully and setting expectations with regard to what you can and can't do is super, super important. And that's one of the things that I've been really harping on, because again, I've just seen those issues come up, over and over and over. Doesn't matter if it's a seller's market or a buyer's market, high interest rate, low interest rate, high volume, low volume. It's always two of the categories of questions that really sort of invoke some very close touch point for you all to the practice of law. And you just have to be careful about that. So that's one area of hotline calls that never changes, right?
And the thing, I was just going to say, we've seen an increase in the after the fact adverse material facts that have shown up. Just because, in case you guys weren't paying attention, 2020 and 2021 saw a massive increase. Buyers were being taken advantage of, or just there was just no inventory. So you had buyers just competing for offers or competing to get properties. And after the fact, it's, buyer's remorse has been at its all-time worst, I think. You have a lot of buyers that feel like now they may have overpaid for the property, or that they got taken advantage of, and they're looking to claw back some of the amount of money that they paid by going after the sellers or the listing brokers. And usually listing brokers get implicated too, because they have E&O insurance. So the other thing to keep mindful is not only the practice of law, but also, be wary of whether you're going to be the one dragged into that lawsuit too. I mean, buyers that go talk to lawyers, there's lawyers that'll take those cases and they may implicate the buyer broker too. So, keep that in mind when you're dealing with those issues.
Yeah, absolutely. And then we've got the, sort of what I'd call market-based stuff. And one of the things that I'm getting a lot of questions on of late, and it's directly a reflection of the high interest rates that everybody's dealing with, is questions and issues related to seller financing, specifically, and some other alternative, loan assumptions, which are not terribly common, but because interest rates are high enough, and a seller who has an assumable loan that's paying 2.5%, 3.5%, that's a pretty attractive marketing vehicle, as well as subject to deals, and those create a lot of risk. But and I know Damian's, I'll let him kind of hit on some of those. But the seller financing thing is, it's funny because we had the mortgage crisis, and up until just after the mortgage crisis, even in our real estate commission approved forms, I think it used to be paragraph 4.7 that was you could lay out for seller carry or seller financing all of the terms of the deal, right? The interest rate, the payments, the balloons, all of the stuff right there in the contract to buy and sell, the commission approved form. And then that went away. And the fact that it went away was not something that I had a lot of questions or issues with, because simultaneously we were dealing with historically low interest rates. And so there was really not much of a need for most buyers to even have to pursue or consider seller carry or seller financing. They could just go get a new mortgage loan on their own.
at 2%.
At 2% or 2, yeah, whatever, very low rates, as everybody recalls and maybe wishes we could go back to. But that created its own, set of economic concerns too. So anyhow, so I never had any questions about it, but now people are like, well, where did that go? Like, how do I do this? And the important thing that changed after the mortgage crisis and really in response to the mortgage crisis was federal legislation, Dodd-Frank, and specifically the SAFE Act, related to how or who could, and the phraseology is offer or negotiate the terms of a residential mortgage loan. And they limited that federally to only 2 categories of individuals: licensed mortgage loan originators, MLOs, or attorneys. And the reality of it is, brokers who are, licensed brokers don't have the ability to do that. And so in a situation where you as a broker are listing a property and your seller's willing to carry back financing, it is, you are offering terms. If you list in the MLS, seller willing to carry back financing at X% for X period of time, and terms that are in the MLS, in the broker remarks or in the public remarks, that would be offering terms, and you're not licensed to do it. And similarly, it came out of the contract to buy and sell, because that would be offering terms in the contract. It would also require the brokers to negotiate terms in the context of the contract. And so that's been the case for a long time. I don't know, probably coming up on about 10 years now, I'm thinking, since this was all implemented. But it hadn't been an issue until the last 18 or so months, when we've seen the interest rates really skyrocket and a lot more interest in, specifically in seller financing. And so I've been reminding brokers as well, you can't do this stuff, and you've got to be very careful. It's a violation of federal law if you're offering or negotiating the terms of residential mortgage loan. And that's one thing that I would say I've seen a real increase in inquiries from brokers on, again, just completely driven by the conditions in the marketplace.
Yeah, I get a lot of questions on the fact of, well, if we can't do seller financing, why do we have a real estate commission approved promissory note and a real estate commission approved deeds of trust? Because those forms are still up there, still available. A couple things though. You want to know the real reason that those were left up there? It's for the lawyers to use. I mean, that's literally why they thought they would leave them up, because they're like, well, we got these great forms, and the lawyers use them all the time, so maybe we'll just leave them up there. So that's one of the reasons that those got left up, because there was discussion about taking them down. But they wanted to have a resource in case the consumer did decide to do seller financing, that the lawyer wasn't starting from scratch. But don't be misled by that, guys. And there are other instances where a broker could be involved. I'm going to tell you, a broker should never be involved with any seller financing. It's too dangerous. And don't be misled by those forms, because I have heard even some title companies, I know Heritage wouldn't be one of them, but say, oh, well, we have these forms, we'll just do them if you put them in the contract. And that's not good, guys. It'll get you jammed up.
Yeah, they're more.
What's that?
We have a question. What constraints or mandates does CFPB require relative to seller financing?
You mean that's on sell? So even if you're a private party seller, there are limitations. Now, I'll let Damian go through those, because I just heard him address that earlier today in a different venue. But what I'll say before he answers that question is, I don't even like to answer that question when I get calls from brokers, because what's invariably happening there, it's a listing broker that's calling me saying my seller wants to offer financing, and they're asking me, their listing broker, aren't there some limitations or things that I can't do, or there's a certain number of transactions or whatever? And I really punt on the question, because when it comes out of my mouth to you on the hotline, it's not legal advice, because that's the terms and conditions and use of the hotline. But when it comes out of your mouth and goes back to your seller, you're giving them legal advice. And there are some pretty significant pitfalls for a seller who is in violation of that. And to the extent that you're the one that's advised them, correctly or incorrectly, if they have liability or meet any of those pitfalls, they're going to come back and point the finger at you. So, Damian, I'll let you go through the couple of quick things.
Yeah, and I don't want to lose the point on this that Scott's making, in the fact that you guys really shouldn't be involved in this. So let me talk about what you can do. But what the CFPB did, or what Dodd-Frank did, is when it passed that federal legislation, what it said was, okay, we're going to say if you offer the terms of a mortgage loan, a residential mortgage, then you have to have a mortgage loan originator's license. That's the default. You have to have a license. And then they said, okay, well, wait a minute, for seller financing, you don't have to have a license as long as you meet some certain criteria. And the criteria is things like you haven't done more than 3 in the last 12 months, and then, or you didn't build the house to begin with. But then you get into some that are really tough, like it has to be a fully amortized loan. Well, most seller financing, what the seller wants is they want to amortize it over 30 years, but then they want a balloon in 5. That says right there, now you have to have an MLO license. The other one it says is you have to have a good faith belief that the buyer can repay the loan. What the hell does that mean? I don't even know how you're supposed to figure out. How do you know that you have a good faith belief? Does that mean now the seller has to go look at their income and do some kind of analysis as to whether or not they're going to, I mean, so there's some tough things in there, but then the last one even says, and comply with all those CFPB rules, which, so you're telling the seller who doesn't have to have a license that now you have to make sure you're complying with the CFPB rules for people that do have licenses, or make sure that you have looked to see if there's other rules that have passed. And it's just, what I want you to get from this is it's very, very complicated. And my suggestion is this, is if your seller wants to offer seller financing, I would send them to an attorney at the time of the listing and say, look, there's all sorts of rules around this. Things have changed. It used to be very easy for us. It's now more complicated. There could be risk for you. What I suggest we do is get your attorney involved now, and then your attorney can advise you about those risks. And if you still want to move forward, let's have your attorney draft up provisions for the contract. So now it's your attorney drafting those or negotiating those terms, not the broker, and for that matter, not even the seller. The attorney can be involved and then work from there. Now, that being said, there are some requirements on attorneys too, that they can't have done so many loans either. So this thing is not easy as it used to be, just so you guys know. So that's why, Scott's saying punt. Hey, you want to do this? Let's get your attorney involved. Let's find out what they want to do. 9 times out of 10, the seller's going to say it's not worth it. And that's okay, because it's probably better that the buyer get a loan anyways instead of them carrying the paper. So that's my suggestions on that. Scott, you have anything to add?
No, I think that's good. I'm trying to figure out, Damian, if a lender has ever gone into making a loan to a borrower that they didn't have a good faith belief that the borrower was going to repay the loan.
I don't know. I don't even know what the hell that means. I mean, at least the lenders have ratios of, loan to value and that kind of thing, as well as, income ratios and that kind of thing. But does that mean the seller has to do the same thing? I don't know. Yeah,
it's interesting, but that's only, I think it's an important topic because I think everybody can agree there's not going to be, anywhere soon, anyhow, an end in sight to what are going to be a perception that interest rates are incredibly high, and they certainly are much higher than they were as recently as 18 months ago or so. So yeah, those are. I mean, that's a market-driven question. The hotline that we're getting all the time. It is funny to watch the shifts or the ebbs and flows in terms of calls, and so many of them are. I spent about the 3 years answering calls on appraisal gap clauses and escalation clauses and all of that sort of hot market problems, waiving inspections, waiving appraisals, doing all of this good stuff that now have evaporated for the most part in most markets. Although there are still occasionally in certain geographic markets and property types, we're still seeing some escalation clauses.
We probably ought to hit subject 2, and then I see we got 3 questions, but let's talk a little bit about the subject 2, because I'm seeing this a lot too, guys. And I know Scott and I have talked about, we talked about this morning as well, is that I'm seeing a lot of these investors coming in, and what they're saying is, oh, wait, here's a seller that has a loan at 2.5%, 3%. What we're going to do is we're going to buy the property from them, and we're going to take the property subject to their loan, and then we'll pay the cash for the difference. And I've seen a couple now where they even put together an FAQ of what this offer means and why it's such a good idea for your seller. And it's just a sales piece to try and dupe sellers into doing these subject to deals. I'll tell you, the only time I've ever seen the subject twos are dangerous for sellers. And the reason is because if the investor looks at this and then they can't make the numbers work or whatever happens, and the market craters, whatever happens, and they just decide, I'm just going to walk away from it, then the seller is the one that gets the foreclosure. The investor has no risk of foreclosure, credits, being chased for the deficiencies, none of that. It all goes back to the seller that would then get hit for all those things, including attorney fees, costs, anything if that mortgage did go into default. The only time that I've seen that I thought that it might be an okay idea, and I'm still not sure I'm in love with it, was when it was an estate and the borrower was actually dead. And that's because obviously you can't chase a borrower if they're dead. So at least they didn't have the repercussions of the loan. But be aware of those things, because the subject to is a little dangerous. More deadly is when I see brokers deciding they want to play in the subject to world. And they're like, oh, I found this great property. I'm going to go buy it subject to, and then I'm going to flip it for $40,000 or $50,000. And I'm just going to tell you, the Division of Real Estate does not like those. They see it as a predatory practice. They see it as brokers taking advantage of some consumer that was maybe in hardship because they had to sell their property. And I've seen a couple times where a couple licenses have been revoked. Now, there was other factors as to why there was a revocation, but at the heart of it, it was because what the investigators and what the division and the real estate commission perceived was that the broker was taking advantage of somebody that had fallen on hard times and needed to unload their property and made a profit at their expense. So, keep that stuff in mind if you're an investor looking at those things. Scott, you have anything?
No, what you said is accurate. Yeah, I would remind sellers of the potential consequences if you're seeing for some reason that kind of an offer. And yeah, they are. I don't want to say they're inherently predatory, but they certainly have some pretty serious implications in the event that the investor just decides to bail on whatever their obligations are.
You want to do some questions, Jen, since we got a bunch that are on this topic?
Yeah. So you can't use very generic terms such as seller will consider seller financing at 6% with 20% down.
I would not. I would say that's offering terms, right? I would use generic terms like seller will consider financing, or seller to consider, carry back financing, whatever. I mean, just leave the terms out of that. I mean, it's when you put them in there, it's just blatant. They're there. They're listed on a public website on the MLS. They're available to everybody to see, and there are people that will complain or at least bring that to the attention of probably they would bring it to the attention of the Division of Real Estate. But to the extent that the Division of Real Estate becomes aware of something that they don't have jurisdiction over, they have an obligation to refer that matter to the appropriate authority. And in this case, it would probably be the CFPB. So I would avoid that for sure.
What do you do on the contract?
I would probably, okay, this is what I've told people in terms of handling it. Remember, it's offering or negotiating the terms of a residential mortgage loan. So you're going to maybe introduce the idea that your seller will consider financing. In the offer, if I'm representing a buyer, I'm going to ask the buyer to specifically email me, like write out, here are the financing terms I would like to offer in connection with this. And I would attach that or copy and paste it in the additional provisions, attach it to the offer. But even if it's ugly, just not to put it in the additional provision, but just say, seller financing per terms attached, and submit that. And then listing broker is going to, give it to their seller. And if the seller wants to counter the terms, then I think they similarly need to be sending a writing doing that. On some level, it's the worst nightmare for a broker, or for any brokers, is to put two clients together with each other to interface. I've recommended in situations where there's active negotiation going on to open up an email chain between the buyer, the seller, both brokers, everybody's copied, and to instruct the buyer and seller, you guys can carry on your seller financing discussion, negotiation through this email chain, reply all, so that we can all see what's going on, because you can see it. You just can't be the facilitator of it in that negotiation sense. And that way you're able to kind of track what's happening on the two parties deal together without being in a place where you're either offering or negotiating the terms. Honestly, it's a bit of silliness in terms of how granular that rule was made. But the safest thing to do is allow the parties, if they're going to do that, to negotiate it. But Damian's point was, I think, the best. If you're a seller, you're going to consider that. Encourage your seller to talk to an attorney up front, figure out how they want that all taken care of, and let the lawyer do it.
Yeah, and that way at least they know if they need a license, or make sure they don't need a license because the attorney's handling it. I want to point out one real quick thing on the contract is that when all those the terms and conditions of financing went away, it was replaced with a provision that essentially says, seller financing, and it says somebody has to provide the seller financing terms to the other side. And then both parties have a right to terminate if the terms of the seller financing are not satisfactory. For brokers, you should just use that provision and then punt on the rest of it to let them figure it out and put it together, because you don't have to have it in the contract. And, I think Scott's right that your buyer can give you stuff and you can be the scrivener to put it in the contract. But the safest bet would be, look, let's just write a contract. We got a general idea as what each other's looking for. We're going to write the contract. We're going to make it that it's contingent upon both of you approving it. And then you guys go figure it out and make sure you're okay with it. And at least keep the broker out of the line of fire or looking like they're somehow involved with that negotiation.
Yeah. Yeah, it'd really be an attorney. You're not going to get an MLO to step in there. The MLOs make their money by closing new loans, not by negotiating loan terms for seller financing.
There's a bunch of them that aren't doing much right now, Scott. So maybe there are a couple out there that would do this. So
that could be a decent supplemental income business model for
MLO seller financing. Got it. Check.
What if a parent makes a loan to their child and they negotiate the terms without the realtor involved?
Totally fine. That works. The parties can always.
The state law, they tried to carve out something for like employers and parents and children, but guys, federal law doesn't make a distinction. Just so you know, it just doesn't. Just leave the realtor out of it.
If the seller's in foreclosure, can the buyer use a subject to contract, or must it be the foreclosure contract?
Well, there is no subject to contract. I mean, and if the seller's in foreclosure, the question is the buyer going to catch up the loan? Because I don't know why anybody would take a property subject to, unless they were betting on the fact that they were going to sell it for more. And then if it doesn't, they'll just finish up the foreclosure. But the Foreclosure Protection Act has specific requirements for if somebody is in foreclosure, 30 days delinquent or in default, don't even have to be in the foreclosure process, that they have to use the foreclosure form if they're not going to live in the property as a principal residence. And there's a whole flow chart that I think the Division of Real Estate has that you guys can go look up if you have questions about when to use the form or when not to use the form.
Yeah, there was a really good in this year's ACU, they did a nice slide that had a really good flow chart. So if you took that class, which you should have by this point, but you will need to at some point this year, it's towards the end, but it's a great, I thought it was a very valuable slide. So check that out.
I think they actually have it on their website too, if you want to go look there too.
And we have plenty of opportunities to still get the 2023 ACU class in. So, and then lastly,
shameless self-promotion.
On Cox Education, that is. Do attorneys have an automatic MLO license?
No, an MLO license, you have to be registered at the state and the federal level as an MLO. Attorneys just have the ability to offer or negotiate terms of a residential mortgage loan. So that they don't have an MLO license per se.
And that's even within confines. I mean, I thought there was something, and Scott, I could be misremembering this, but I thought there was something in Dodd-Frank that said, so long as it's not their primary business or that they don't do it all the time or something along those lines.
That sounds about right.
And then lastly, can you talk more about assumable loans, like the pros and cons?
Well, interest, I mean, the primary pro is interest rate, right? In other words, you've got somebody who has a seller who has a loan that's locked in for whatever duration at 3% interest, and a buyer who can step into those shoes and to the benefit of that interest rate. I mean, that's the number one pro. Con can be timing issues. I mean, most loans aren't going to be, conventional loans aren't going to be assumable. I think you find them in FHA or VA products. You're just not going to, it's not a terribly common thing. This does come up quite a bit, specifically like in Colorado Springs, I think, because there's a large military community down there. And on those loan types, the assumption is available. And if everybody's willing to jump through the hoops on that, then it's a great deal for a buyer. And that can sometimes be re-acknowledged, or, the benefit of that back to the seller in terms of days on market, potentially a little bit, higher purchase price. And there's some real benefits to it. All right, should we move on? Are we done with our questions?
Yeah, I think we got the questions done. Is it time to talk about What was that one? Antitrust, I think.
Yes. All right. Well, so I guess there's nothing more important in my view, and I've been not just saying this in the last year. I've been hitting on this topic and saying this since, early first half of 2019. So it's been a number of years, and that's when the lawsuits, the federal class action lawsuits, kind of the two main ones really hit. One was in March of 2019. One was in June of 2019. And the original lawsuit, Moral is the name of it. That's the lead plaintiff in the federal class action lawsuit. That one has implications in Colorado, as what they describe as representative MLSs include RE Colorado and Pikes Peak MLS. So those two MLSs, and sellers who since 2016 have sold properties and paid through their brokerage firm cooperating commissions on those MLSs. And so anyhow, I'm not going to break down the lawsuits. If you haven't been paying attention to this stuff, then you should be, and you need to be. But the derivative impacts of those two lawsuits have been significant, and they're, I think, going to continue to be significant. Not long after that, those lawsuits were filed. The Department of Justice commenced an investigation into really the same issue, and all of this really has to do with the mandatory offer of compensation that has been embedded in realtor-owned MLSs throughout the entire United States of America for generations. It's that cooperating commission, and somehow that is representative of the fact that the respondents are NAR, Keller Williams, Remax, Realgy, which is now Anywhere, and Home Services, or Berkshire Hathaway primarily. Those five respondents have colluded and conspired to essentially fix commissions or inflate them in some manner. And so the Moral matter was certified as a class after about 4.5 years of kind of litigation going back and forth to demonstrate their class certification ability, or that they should be certified. It was finally certified by the federal district court judge in Illinois about 2 months ago now. And that really kind of turned up the heat a little bit in some respects. And so since that has occurred, I think a couple of things have occurred. Most of you have probably seen about 4 weeks ago now, there was an announcement that Anywhere, or formerly Realgy, had agreed with the plaintiffs to settle out themselves out of that 5-member respondent group. That needs to be blessed by the federal district court judge, and I think typically that would probably be blessed, assuming that both the plaintiffs and the respondents agree. So they've probably removed themselves from that. Remax, there's been some chatter that there's been an offer, that they made an offer. I don't know that the news, and Damian and I have talked about this a number of times, and the stories are kind of vague about whether the offer for I think it's $55 million to settle out was accepted by the plaintiffs, or if it was just made to the plaintiffs. The articles and the news that I've been reading hasn't been terribly clear on that point. But they're trying to get out of the lawsuit as well. And the reason that I think there's such concern about this is in the judge's certification order that was issued a couple of months ago, she basically articulated that, hey, the plaintiffs have to prove their allegations. They've got to prove collusion, the antitrust violations. But if they do, then she confirmed that the plaintiffs have articulated damages or potential damages in the amount of $14.7 billion. So it's a massive lawsuit. And then in antitrust litigation, in civil litigation, if there's an antitrust violation that's found, then those damages are eligible for trebling. And so we're talking about something in excess of maybe $40 billion. And that's really, I think, put a little bit of a fire under some of the respondents to consider, how do we sort of stem the flow of our potential liability here? And so those two offers of settlement and potentially settling out are significant, I think, in terms of at least their perspective on the lawsuits. And then you've got, assuming that Remax and Anywhere actually get their settlements accepted and approved, then you're going to have 3 respondents that I think are going to be considering, what are the potential implications of them remaining in a lawsuit where you could have in excess of $40 billion in damages. And so that's had a big impact in a lot of ways. One of the ways that more recently this had an impact is about a month ago now, maybe about 5 weeks, Bright MLS, which is the second or third largest MLS in the United States of America, they basically said, hey, we're a realtor-owned MLS, and so we are bound by NAR's MLS policies, which require an offer of compensation to a cooperating broker. And NAR for generations has always interpreted that an offer of compensation, while there's never ever been a mandatory minimum offer in terms of amount, it has always needed to be reflected in either a dollar amount or a percentage. And so that could be theoretically a penny, it could be $1, it could be, a thousandth of 1 percentage point in terms of an offer, and that would qualify. Well, that's always been MLS policy throughout the United States of America. And Bright, about 4 weeks ago, they said we're not going to require an offer of compensation be a dollar amount or anything, or we view essentially that zero is an offer of compensation. And so Bright said, forget about NAR's policy, we're not going to follow it. And NAR basically then, I think, because of the position that they're in with regard to these lawsuits, they were put into a place where they basically said, hey, we're gonna revisit how we interpret our policy, and basically we agree that zero is an offer of compensation, percentage or dollar wise. Zero does qualify. And since then, as most of you guys know, RE Colorado has acknowledged that that's now their position. I think a number of MLSs in the state, throughout the state of Colorado and throughout the country, are going to be basically following the same suit. And again, all of it related to the federal investigation, to the lawsuits, and just perceived potential liability by some of the MLSs with regard to this issue. And honestly, it makes sense. The difference between a nominal offer of compensation of $1 and zero is insignificant in a way. And so I think it is probably an appropriate acknowledgement from NAR to reanalyze their policy and reinterpret their policy. And I think it's going to follow suit probably throughout the United States of America. The most important derivative issues, Damian, did you want, I feel like I'm just.
No, go ahead. I think you're doing a fantastic job. You're
used to listening to hear me talk, aren't you?
Yeah, well, it's the only thing I get to do when I do these things with you.
Mm-hmm. The most important thing that comes out of this is the fact that as an industry, we have to do a better job, and I mean specifically buyer brokers, because in Colorado, as you guys know, you have to have an exclusive right to buy if you're going to list a property, or an exclusive right to sell if you're going to list a property. That's required by the Division of Real Estate and License Law. It's required by your MLS rules. But we don't do that for buyers. We have to get better as an industry, buyer brokers, in getting those things. We have to get more comfortable not relying on the MLS to articulate our commissions, or the listing broker or seller to pay our commissions, but for us to negotiate our commissions with the buyer. And the only way that can be done is getting, in Colorado at least, an exclusive right to buy executed and addressing your success fee in your exclusive right to buy with your buyers. And honestly, it frustrates me that we as an industry, and by that I mean the brokerage industry, have been so willing for so long to work for free, right? There's been a real lack of willingness to demand that buyers get their skin in the game. And in Colorado, we can do that by delivering a broker disclosure to buyer, which in our state, that requires you as a broker to provide and offer the uniform duties to a buyer. And that same document requires the buyer to give you squat. They owe you nothing. You can't be sign crossed on. They can cheat on you. They can let you show them property for weeks or months or years at a time, and then go decide to write an offer with their cousin who's a realtor in a different market. It doesn't give you any protection. And part of that's been our problem and our fault for relying on the MLS to articulate our commissions for a long time. And it's allowed, I think, a lot of realtors to get lazy and to not be willing to even analyze or define, let alone begin to articulate their value proposition. And it'd be one thing if you didn't do anything, but what blows my mind is you do so much. It's truly mind-boggling what a buyer broker does in the course of a transaction to work for, protect, advocate for their buyer. And we just haven't been willing to take that next step, which is, hey, this is what we do. If you're going to work with me, you need to have skin in the game here. And part of that discussion is going to be how I get paid. It's going to be me negotiating my success fee with you, buyer. And I say this often, the very best brokers that I meet throughout the state, and I travel a lot in Colorado. I talk to, all spectrum of successful brokers. The most successful buyer brokers, they don't work with buyers in the absence of an exclusive right agreement, period. That's their policy. The really, really good ones don't work with buyers in the absence of an exclusive right agreement that says buyer will pay, seller may pay, and checking that box in paragraph 7. And that means that they have established what they work for as a buyer broker, as a buyer agent. And we just don't do it often enough. Too many people are willing to just or work for free and essentially say, hey, I'll be your TB, even though you act like an agent, even though you're only disclosing transaction brokerage, you only have a transaction brokerage relationship. But what do you do throughout the transaction as a buyer broker, as a TB? You advocate for them, you fight for them, you work for them. They demand it because that's what buyers need. They need agency. They want your advocacy. They want your advice. They want your interpretation. And you're not allowed legally in Colorado to do those things if you're a transaction broker. And yet we do them all the time, and we do them for free. And the other thing that blows my mind is that what other industry works like you all work? You don't get paid. You don't get paid at all unless your client is successful. If your buyer is not successful in finding a house, it doesn't matter how many hours, time away from your family, your friends, your hobbies, how many gallons and gallons of gasoline you burn, how many late night phone calls and distractions and runarounds you get squat. And similar for seller, if you're not successful in finding a buyer and putting their house under contract and closing that contract, you get squat. I mean, if that's not a value proposition in and of itself, I don't know what is. But we, on the buyer broker side, we're just willing to work for free without demanding that our clients get their skin in the game. And it begins and ends, in my view, with getting better at identifying what we do, what our value is, articulating what it is, and getting really, really comfortable with, patting yourself on the back and selling your services and demanding that you work pursuant to an exclusive agreement. So anyhow, I'll step down off my soapbox now.
No, I think it's good. I think people need to hear this, Scott. I mean, it's important, and our industry is changing, guys. And if you represent buyers, you better get comfortable with the idea that you get paid to do a job, and your buyer should understand you get paid to do a job, and that you should get paid to do your job. And I've always said that our value proposition in Colorado is better than even other states because you guys have that quasi license to practice law, the ability to explain contracts and fill them out and help them through that process that doesn't necessarily happen in other states. So but this is a wake-up call. We have to start doing better about it. I see my son is here. Did you see that, Scott?
I do. Hi, Jill. You look amazing and well relaxed for having such a young baby there.
Well, it's definitely easier the second go around, but I haven't slept in 7 weeks. Anyone with kids knows.
Well, Damian was in Vail last night and he slept like a baby, I hear. So he owes you one tonight, I think.
I love that somebody said bringing Quentin on during the antitrust was a good play. It made my stress level lower.
It made mine a little lower too. I get a little worked up about it. But I've been a realtor for since '99. I think I was originally licensed, and I don't practice real estate brokerage anymore. And I really was only a commercial broker to begin with. So commercial brokers have never had for years the benefit of the MLS and an offer of compensation in Colorado. And so they're very good about making sure they're figuring out how they're going to get paid in a transaction from deal to deal to deal to deal to deal. So anyhow, I've worked with realtors. My mother's been a realtor in Washington, Bellevue, Washington area for 40 plus years, and I realize the value that you guys bring and what you do, and I get passionate about it because it does frustrate me that our industry is under an attack in some really, really unfair ways. And Damian and I have talked about this a lot. What's overlooked so often is the benefit to sellers from how our system in the United States of America has worked in so many respects.
Yeah, I want to make sure we touch on that because I think brokers as general, listing brokers, this is not just a buyer broker problem. I mean, when you're talking to a seller and you're discussing that offer of compensation, what are you going to offer to another broker that brings the buyer, I mean, you need to discuss the pros and cons, because, you know, if a buyer has to pay their buyer broker a commission, then that's less house that they can afford. So if a seller thinks, you know what, zero, I'm not offering anything, that's fine, but that means it is going to lower the buyer pool, because if a buyer doesn't have enough cash to pay the buyer broker that may have an agreement that says that you have to pay me, buyer, if the seller doesn't pay me, as well as you know, coming up with a down payment for that property, they may be excluded from making an offer. So, you know, there is benefits to the sellers. And I think as listing brokers, you have to have that conversation with the sellers about how our industry works and how their comps have that cost of sale built into them, because it does have commission paid to buyer brokers as well as listing brokers, and discuss with them, what does that look like and what's going to be best for you, seller. And frankly, the amount that they offer may change depending on the market. If it is a seller's market in 2021, we saw commissions getting compressed. We saw the market at play with how much was being offered. Likewise, if we go into a recession, which is being forecast on and off and nobody really knows, but if we end up there, you can see where now, you know, all of a sudden sellers might have to pay more because they want to entice the buyer brokers over, or the buyers say, hey, buyers, we want to pay your obligation for you so that you don't have to, so you'll make an offer on our house. And that's something that gets lost in all this, because buyers can't just roll their commission into their loan. That's just not an option. So it does have an impact on their ability to buy the seller's property.
So we do have a couple of questions. Do you think VA loans will change and allow the buyer to pay our commission?
So I have no inside information. This is just purely me speculating. I've got to believe that NAR is figuring out from a government affairs strategy at the federal level through Congress. If we see a situation where there's not offers of compensation, then yeah, you're going to find a lot of buyers, not just VA buyers, but a lot of buyers who need representation and simply aren't able to obtain it because they don't have the money to come out of pocket and get commissions. And so I'd like to believe that there's some advocacy plan in place to maybe see the extent to which the Congress might modify lending criteria or guidelines in Fannie, Freddie, and VA and other places to allow for some overt amortization of commissions in a residential mortgage loan. I mean, that's what you see in the vast majority of the rest of the world, other first world countries, is there's not two brokers, and the buyer is the one that doesn't end up with an advocate or an agent or somebody who's really representing their interest in a transaction. And that has not been the culture here in the United States of America, and for good reason. Buyers, if they can't afford their own representation, will be taken advantage of.
And more importantly, why would anybody think that's a better system where the buyer is not represented? I mean, we changed from that system years ago when we used to have seller agency and seller sub agency. And it changed because buyers were demanding that they had representation. They were demanding that advocacy. So to think that we should go back to something else just doesn't make a lot of sense.
Yeah, the market will dictate, I think, a lot, and it really always has. I mean, we've seen commissions vary, you know, across markets, you know, for years. Technology has changed access to information and data availability for buyers directly as consumers. We've seen, you know, a lot of brokerage business models that have been, you know, very varied commissions or flat rate commissions or other alternative, you know, options. So anyhow, I think there's a lot of states that do have limited services agreements, and that we don't allow those here in Colorado, but there's other states where you can find like menu option kind of brokerage services and fees, but that doesn't work here in Colorado based on our state law preclusion on that. So anyhow, get your buyer exclusive rights to buy executed, please. You deserve it. You work very, very hard, and it's the best way to ensure in a world where compensation is not necessarily going to be guaranteed through an MLS, the best way to ensure that you are negotiating what your time and investment in a transaction is worth as a buyer broker. And that would be through the success fee in your exclusive right to buy. Yeah, last point I'll make, and I think most of you guys are probably, people that show up on these kinds of things are clear on this, but There's only one way that you're ever able as a buyer broker to articulate your brokerage commissions in the contract to buy and sell. Because remember, you're not a party to that contract. It's only the buyer and seller. The only way you can do that is if you have, as a buyer broker, an exclusive right to buy, and you've checked the box, buyer will pay, seller may pay, and whatever your success fee that you've negotiated with your buyer is more than what is being offered in the offer of compensation in the MLS. If that's the case, because the buyer is on the hook to pay you, if the seller doesn't, or if the listing brokerage firm doesn't, then it's in the buyer's best interest to instruct you to write into their offer to purchase the property your commission so that they don't have to pay it. But other than that, you aren't allowed in any way, shape, or form to address your commissions in the contract to buy and sell. But if you've got that box checked and you've got an exclusive right agreement, then you can. And that's going forward, I think the very best way to assure that no matter what properties your buyers may or may not be looking at, you've got the ability to earn what you've rightfully negotiated as your success fee.
Yeah, and I think that kind of hits a couple of these questions with what changes do you think we'll see because of the lawsuits? Obviously, we're going to see that we got transparency that's coming either way, but we're going to start to see there could be compression of commissions. There could be buyer brokers that, if you don't have that commission, you might be working for free for your buyers. We're going to see different. Who knows what's going to happen in the MLS? Nobody has a crystal ball as to what that's going to look like. But it's just, this is the change. Is you need to start making sure that you have that in there so that whatever property, as Scott said, that your buyers are looking at, you can at least figure out how your compensation is going to get paid.
So true.
Do you foresee this changing the landscape for iBuyer programs and flat rate brokerages? If so, how do you see it changing them?
I think we've had flat rate brokerages for years. And like I say, brokerage models that are not just a conventional, or conventional is not the right word, but your traditional brokerage model, where there's an ability of a seller to offer, and or buyer brokers who will work, at whatever rate structure they have. I mean, those aren't new. iBuyer programs, I think, I'll tell you what I believe is, to the extent that we see compression in buyer broker commissions that go below what a buyer broker can afford to work for themselves, you're going to see an increase in unrepresented buyers, period. That's going to lead to probably more transaction brokerage for listing brokers, more double ending deals potentially, which comes with its own potential exposure. I think there's nothing more difficult than being a transaction broker and being a legitimate transaction broker. It's a very, very hard line to walk when you're working on both sides of a transaction. Many of you who've heard me speak before know I really dislike the transaction brokerage relationship as a starting point. I understand that there are times when it's necessary, but as a starting point, I just believe it's a relationship that a broker creates a lot of liability for themselves, because it's almost impossible to be a true transaction broker in the definition or interpretation of that brokerage relationship by the Division of Real Estate. So I think you'll see more transaction brokerage. I think you'll see more unrepresented buyers. And some buyers, hey, I've got access to the information. What do I need you for? I don't. And this is part of the problem, is brokers have for too long been able to rely on the fact that, well, if as a buyer you need me, and my value proposition is I have access to the MLS. Well, that horse is out of the barn. It's been running and it's gone, and it'll never come back. It's been gone for many, many, many years. So that is not enough. The real trick, though, is on some buyers who believe, well, since I have access to the data, I can see available properties. I can see, historic pricing, and I can see, these things. That's all I need. I don't need you anymore. But buyers don't know what the hell to do with that information. They don't know how to distill it. They don't understand. I mean, you guys as buyer brokers, you've been in every single one of those sales comps that are being listed. So you understand the differences in quality. You understand how to distill the information, how to break it down, how to use it as leverage in negotiations on behalf of buyers. I mean, that's just one area of value proposition that, again, we don't really ring that bell for ourselves. And it's left a lot of consumers with the thinking that, well, gee, what do I need a broker for? I can see the information. I can deal with the contract. I can get the listing broker to write a contract. I don't know. It's a silly misperspective, but I think we will see definitely more of that if we see significant compression in commissions and or the offer of compensation go away entirely in certain markets. So.
Okay, couple more questions. What does the verbiage look like in additional provisions on the CBS stating the seller pays buyer agency commission?
Well, remember, the contracts between the buyer and the seller, so it's got to be a promise from the seller to the buyer to ensure that the buyer's representative receives compensation. What it can't be is language that essentially says, seller agrees to pay broker. It can't be a promise from the seller to the broker. It's got to be a promise from the seller to the buyer to ensure that the buyer's broker is compensated so that the buyer broker doesn't have to. So, however, anytime, I know Damian agrees with me on this, keep it simple, stupid. The KISS principle is the perfect rule when it comes to writing any additional provision, including language like this. But you do have to keep in mind, and I hear a lot of brokers that get tripped up on this, that you can't make it an agreement between the seller and the buyer's broker. It has to be between the seller and the buyer. And from there, keep it simple, stupid, as with all additional provision language.
Okay, last question. How does the structure of IRIS differ from RE Colorado and Pikes Peak MLS? Scott said only RE Colorado and Pikes Peak are subject to the antitrust decision, correct?
Well,
I think what they're asking is, why didn't the others get sued?
That's a question that would be for the law firm in Chicago, Illinois, that initiated the moral matter, how they identified what. So what they did is there's 5 respondents, as I described, and then they named, I think it's 25 representative MLSs is what they're and RE Colorado and Pikes Peak were one of them. It could have just as easily been IRIS. It could have just, pick your MLS. I don't know what the thinking was in terms of the MLSs that they identified. I do know, and to some degree, it's the largest MLSs in some pretty significant markets. And so, but the difference between, call it Pikes Peak and IRIS, I don't know why one was left in and one was not. And so that's, like I say, a question for the lawyers. But again, it's not the MLSs that are getting sued. They're not respondents. They are they merely were named to establish the plaintiff pool for the federal class action lawsuits. And so, and Damian and I talked about this a lot too. So these settlements as an example, well, there's no way that the settlement could cover, let's say that another law firm comes and names a different law firm, different plaintiffs. They come and they name IRIS as a representative MLS in a different lawsuit, and sellers that have sold an IRIS. I'm not sure that there's a way to settle those out, because those sellers who would have been allegedly harmed by the behavior would have never had a chance to participate in the class action, in the original class action. And so I'll come back to kind of where I started this is that it's going to be an incredibly interesting, 6 to 18 to maybe 48 months in terms of some of the twists and turns with regard to the world that we're all living in. Not all of it bad, and maybe some of it much for the better. I'll say this as well. I asked Marcia a couple of weeks ago for a number because I was doing a presentation, and it's 44,000, I think 628, I think was what it was as of about 2 weeks ago, total active licensees in the state of Colorado. That's a lot of people, and a lot of people who probably are dragging down our business and the quality of the professionalism that so many of you all offer. And I got to tell you, if you're just hanging on, you're kind of doing some deals, kind of not getting your education, kind of not maybe showing up and doing your ACU on New Year's Eve because you forgot, if you're living in that world as a broker, I think you're going to experience some really, really challenging times as the market changes. I'm not just talking about interest rates. I'm not talking about, buyer market versus seller market. I'm talking about the entire ability. I don't believe there's a lot of, out of that 44,000, there's a lot that do not have a value proposition. They don't add value to a transaction, never have and never will. I think they're screwed in a new frontier market. And I think they maybe deserve to be. And I think it'll be better for a lot of the market. So there's some implications to doing business in a more difficult market that might be good implications. And that might just be one of them, because, it's always the bad apples that spoil the bunch, or whatever the saying is. And I'm always surprised. 44,600 and some total active licensees. That's a mind-boggling number for a state the size of Colorado. So I don't know. I don't think we'll see that. I don't think that number will resemble that in 3 years or 5 years. Not just because of maybe a more difficult inventory / interest rate market, but also because of people's ability to thrive or even produce anything in a more difficult market where you've got to negotiate your commissions with your buyer.
Well, that's our 3 o'clock cutoff time. So I just want to say thank you both to Scott and Damian, as always. And then I don't know if everybody on this call knows, but Jill actually has a YouTube channel that she uploads all of her industry updates on. I'm going to drop that link here in the comment box. And then thank you for your participation. Our next one will be November. Damian, do you know offhand? Hold on. November 2nd. November 2nd at 2 p.m. And it looks like it's contracts and forms update with Damian Cox. So
oh yeah.
Yeah. So he'll be ready for that. As always, please check out our classes on Cox Education. Again, we have a lot of the 2023 updates, and then we'll be rolling out the 2024 come January. So thank you again, and we'll get that video or this video uploaded and sent out probably in a week. Please be patient. Jill has a baby and she edits and uploads. So I know we got a lot of emails for the last one, so it takes about a week.
Jill has 3 children, FYI.
She does. Three boys. Mm-hmm. And a couple horses, right?
Well, thanks everybody. Thanks, Scott, for all your time. Really appreciate it.
Absolutely. Thank you guys. And thank you, Damian, for everything you do.
Yeah, thanks guys.
Bye.
Bye.